everyone. I'm Katie Glenn Bass. I am the Research Director at the Knight First Amendment Institute at Columbia University, and I want to welcome you all to today's event on lies and elections. This is the second event the Knight Institute is hosting as part of an exciting year-long exploration of lies in the law, spearheaded by our senior visiting research scholar, Genevieve Lake here. Genevieve is a law professor at the University of Chicago, and she's one of the most creative scholars thinking about the First Amendment today. Over the next several months, Genevieve and the Knight Institute will host a series of public conversations with scholars, journalists, and practitioners, exploring what the law can and should do, or if it should do anything at all, about the problem of lies and deception in the mass public sphere. Details about the next event in this series on lies in the press will be available on the Knight Institute's website shortly. I want to thank Atiba, Janelle, Matt, and Rick very much for joining us for this. It's an honor to have you all here, and this is really an all-star lineup for this topic. For those in the audience, I also want to let you know that each participant has written a brief reflection on some of the questions we'll be digging into today on lies and elections. They're all very thoughtful, interesting pieces, and we'll put a link to those posts in the chat in a moment. And now I'm going to turn things over to Genevieve. Thank you so much.
Hi, everyone. My name is Genevieve Lake here. As Katie said, I'm spending the year as a senior visiting research scholar at the Knight Institute, thinking a lot about lies and the law. And today we're going to have a conversation, a roundtable about the question about election-related lies and how the law should regulate them. Now, I should say that elections have always been sites of special legal regulation in the United States. Some of the oldest speech laws on the books are laws enacted before the United States was the United States. A number of colonies passed special laws designed to protect the sanctity of the ballot box by making it a crime to coerce or intimidate voters to vote against their conscience. Since then, obviously, the law regulating elections and election speech has grown very complex and more elaborate. But in recent months, years, I think the question about, in particular, election-related lies has come to prominence, has become a pressing, thorny, I think both regulatory and political problem as a result of two developments. So the first is obviously Trump's big lie, the lie, or really many different lies, about the integrity and the outcome of the 2020 presidential election that President Trump and his supporters disseminated via Fox News, on social media platforms, at rallies, in any context they could. And these lies appear to have had a remarkably successful, effective staying power, at least, insofar as I think even in recent polls, significant majorities of registered Republicans continue to report doubts about the outcome of the election. These are powerful, significant lies that are hard to escape. And the lies, I think, raise this question, which I'm hoping our panelists today talk about, which is, do we need to expand the regulation of lies and elections, which, to the extent that federal and state law does restrict lying about voting, only restricts lying about the process of voting, not the outcome of voting, to encompass these kinds of lies? And then, of course, the second development pushing this question about election-related lies to the front pages is the I think, pretty expansive discourse of election-related fraud. This claim that Trump and others have made that voters are in significant numbers lying about their identity when they vote. Now, these are claims about another species of election lie, not lies about the outcome of election, but lies about identity when you vote, or other deceptions used to vote unlawfully. Now, these claims, which are part of the big lie is also in part about lies, are being used to justify the imposition of voting restrictions across the country. Now, the result of these two developments is that we are living at a moment in time when half the country is worried about lies about the election results and perhaps wants to use the levers of state and platform power to do something about it. And the other half of the country is worried about voter fraud, in part because they believe the lies about the outcome of the election and want to use the levers of state or platform power to do something about those lies. It is in this difficult, I think, very interesting, but also precarious moment that we're coming here to talk about the really difficult questions raised by the regulation of election lies in a divided and polarized America. And I'm so pleased to have four real experts join me to talk about these difficult issues. So in no particular order, I want to introduce the panelists today. We have, this is just going according to my screen, We have Rick Hasson, who's Chancellor's Professor of Law and Political Science at the University of California at Irvine, and is co-director of a brand new and very exciting center entitled the Fair Elections and Free Speech Center, which I think takes as its primary concern many of the questions we're going to be talking about today, the relationship between speech and voting. Rick is also about to come out with a new book from Yale University Press entitled Cheap Press: How Disinformation Poisons Our Politics and How to Cure It. Those of you who are interested in the topics we talk about today, I think might be interested in the book, and it's coming out, I think, in March. Next, we have Janelle Bird-Chichester, the director of the Thurgood Marshall Institute of the NAACP Legal Defense and Educational Fund. The Marshall Institute, which is inspired by the work of Justice Marshall at the LDF and launched in 2015, conducts social science research, does targeted advocacy campaigns, and public education in pursuit of racial justice. And Janelle was one of the people who came up with the idea of the Thurgood Marshall Institute. Next, we have Atiba Ellis, professor of law at Marquette University Law School, an expert on voting rights, whose work focuses in particular on how different conceptions of the right to vote work to exclude and disenfranchise voters, and who recently published a paper about the epistemic crisis as it relates to voting. And last but not least, we have Matt Perrault, who's a professor of practice at the School of Information and Library Science at the University of North Carolina. His work covers a wide range of topics about social media platforms and the regulation of speech, but his recent work focuses on the question of platform regulation of political advertising and misinformation in particular. I'm so pleased to have all of you here to help us think through these really difficult questions. A note on format, both for the participants and for the audience. So the plan today is not to organize things like an ordinary panel. Panels in the age of Zoom, I think, are a dime a dozen, and I want to mix it up a little bit. The idea is to have a conversation. These are really difficult questions. These are questions that I myself, I don't know the answer to any of the questions I'm going to be asking you, just a heads up. So I think it's most helpful for us to really engage with one another. And so they're not going to be prescripted remarks. Panelists have not been asked to prepare a little talk. I'm just going to ask questions to get things going. But after that, there's going to be no preset order. So I encourage everyone here to disagree, to jump in, to respond. The idea is to have as interesting, illuminating, and rigorous a conversation about these questions as we possibly can. Now, audience members, you will also get an opportunity to join in the conversation. Please submit your questions in the chat, and at the end, we'll leave time for Q&A. Okay, so that's all prefatory. So let's jump into the discussion. I thought I would kick things off by asking, again, I guess, re-upping the question I asked as a prompt for your really rich and interesting blog posts, which is to think about whether lies about elections are special, and if so, why, and how do we define the category of special election lies? Under existing First Amendment law, the general presumption is that political lies cannot be regulated or cannot be easily regulated. Now, there are exceptions, and one of the historically important exceptions has been lies about the time, place, or manner of voting. But these are obviously not the only kind of lies that we might imagine to be relevant here. So I was just thinking about the various permutations of what we might think of as election-related lies. I came up with 4, but I'm happy to hear if there are more. So the traditional lies about the time, place, and manner of voting. This is the kind of lie that we have regulated in the past. Lies about voter identity, the kind of lies that go to the question of voting fraud. But there are also lies about the outcome of the election, like the lies that were a big part of the big lie. These we haven't traditionally treated as the same, subject to regulation as the first 2. And then finally, I came up with the 4th category, which is lies that might be relevant to how people vote, but aren't directly about the election. So for example, we might think lies about who a speaker is. Someone claiming to be a Black Lives Matter activist who says on Twitter, I'm voting for Bernie, everyone should vote for Bernie, but is actually a Russian troll who's doing it to split the Democratic vote. That seems to me to be an election-related lie. Does that fall into the same category? Is that different? How do we think about the exceptionalism of election-related lies, and how do we define the category? Thoughts? Rick, you wrote about this in your blog post. I thought maybe you could start us off.
Sure, and it's great to be with all of you today. I would start off by drawing a distinction which kind of builds off of what you said in your introduction, between lies about election speech, when, where, and how people vote, and lies about everything else, lying about whether it related to an election, lying, for example, about being a Bernie Sanders supporter but actually being from Russia, or lying that a candidate has voted to raise taxes when in fact it was a vote on fees. The way that we've normally thought about the latter category is that counter speech is the best remedy. And I would point to the Supreme Court's decision in a 2012 case called United States versus Alvarez, where the court, although the court was divided on the particular question in that case, which is somewhat peripheral to what we're talking about, it seemed that all the justices agreed that having the government regulate false speech in the context of elections is quite treacherous, because it puts the government in the position of censor. It puts the government in the position where they might be trying to manipulate the outcome of an election. In subsequent cases after Alvarez, lower courts relying on Alvarez, such as a case out of the Eighth Circuit, have said that laws that regulate false campaign speech likely violate the First Amendment. But I think we can draw a line and say, if you lie about when, where, and how people vote, that could be permissibly regulated. The Supreme Court pretty much said that in a 2018 case, I believe it was, a case called Mansky, about a ban on political attire in polling places. Again, that issue was somewhat peripheral to what we're talking about, but along the way, the court said, we have no doubt that a court could prevent someone from, that a state could prevent someone from lying about when, where, and how people vote. So I think that is pretty clear. The case of lying about a past election, lying and say the election is stolen or rigged, as we saw what Donald Trump did, and which is incredibly dangerous, convincing millions of his supporters that the last election was stolen, and as I've argued, laying the predicate for a future subversion of American elections. I think that is one of the toughest cases. And we might want to get into this a little bit more as we go on. But there's two problems with trying to regulate that speech. Number one, some of these are maybe statements of opinion rather than fact. That they may be hard to prove or disprove and regulate in real time. But number two, the main reason I think for allowing the regulation of speech about when, where, and how people vote is that you're worried that people are going to be disenfranchised from the election. If the government has a compelling interest in running elections where voters can actually vote. There's currently a prosecution for a Trump supporter back in 2016 who lied and told people that they could vote by text, and that lie potentially disenfranchised people. But when you lie about what happened in a past election, you're no longer disenfranchising people or running the risk of disenfranchising people. Instead, I think the argument for regulating that kind of speech would have to be that you're undermining the integrity of future elections. And I find that to be a very hard question, and I'm somewhat on the fence as to whether or not that sort of speech can be eliminated. For speech that can't be eliminated, I think the better way of dealing with this is through disclosure that it's a Russian bot that is the one that is claiming to be the Black Lives Matter activist. And there's all kinds of disclosure rules, which I propose in my cheap speech book, that would be much better than the kind of disclosure rules we have now, which pretty much don't reach much activity that's on social media.
Thoughts, responses? Anyone?
So I certainly agree with the easy case versus hard case distinction. The troubling thing for me when you look at federal law is Congress hasn't even succeeded in addressing the easy case. So currently there's no federal law on deceptive practices. It seems like that is an important first step for a bunch of reasons. First of all, I agree that it's an easy case. Intentional voter suppression seems, at least to me, like something that we should prohibit and prohibit by law. If that were done federally and with federal criminal law, it would have a whole bunch of auxiliary consequences that would really be very beneficial. One is that federal law enforcement officials could work with tech companies to get information when they believe that the law may have been violated. So it would open up all of this opportunity for law enforcement compliance with tech companies that doesn't currently exist now because there's no federal law that would be the basis of those government requests for user data. The second is that Section 230 of the Communications Decency Act, which is often framed Often in the current conversation is framed as a complete bar to platform liability, but it's actually not that. There's an exception in Section 230 for federal criminal law. So if we pass federal criminal law dealing with voter suppression, then in some cases where you could show that a platform met the criminal standard, that platform could actually be potentially liable under the federal statute for if it were to violate it. Section 230 would not be a bar to those cases. So the hard case, I assume, is the one that we're going to spend most of our time today talking about. But I find it troubling that we haven't even addressed the easy case. And I should just make one other point as well. I think it's important not just because Congress would be defining the scope of criminal activity, but because it would give the Supreme Court an opportunity to outline in clearer detail exactly the prompt that I think you put to all of us, which is what is the scope of permissible line in an election? I don't think there's sufficient case law on that right now. And it would be helpful if there were.
Yeah, I mean, what's interesting?
Go. No, I was just going to interject that it's interesting in terms of thinking about the easy case versus the hard case. And just thinking about the easy case, I think that prior to the rise of the internet, there's a number of laws on the state level that prohibit things like robocalls that are deceptive. And I mean, the enforcement of those laws might be hit or miss. And my colleague Gilda Daniels wrote a whole article called Voter Deception, but it's sort of pre-internet reality. So I think that the problems that we're talking about here are about evolving the law to deal with this long-term problem of deceiving voters in terms of time, place, and manner, and realizing that it gets far more complicated when we're fighting Russian bots and internet disinformation as opposed to robocalls and leaflets, So there's a gap. And I think it's right that this gap needs to be addressed, and it needs to be addressed nationally.
And I'll add one complicating factor, which is I think that, this is a terrific conversation about how we can control it kind of from the law enforcement approach to restricting false statements and untruths and lies in the electoral process or related to elections. But I also wonder what we can do to help the average person, the voter, protect themselves from those lies. And so I would like to hear from folks who are more expert on this than I am about what we can do in terms of, I've seen suggestions of making sure that people control their own data. So they can't just target groups, African Americans, as was done in the 2016 campaign, have all this data that allows folks who want to manipulate the electorate to manipulate the electorate because they know who you are, where you live, how you, kind of your political affiliations. So I think an important part of this conversation also involves how we control the access of of information that the social media platforms have that have been manipulated in the electoral process. It's just one piece of the pie, but I think it's an important piece to include in the discussion, because the enforcement of this, even if we get good laws, the enforcement of it can be a thorny, question in terms of its effectiveness.
I think that raises a really important point about drawing distinctions between the kinds of harms that happen through social media that are from lies versus things that are not lies but are still potentially damaging. So, saying that Hillary Clinton would not be a good president for African Americans, that's a statement of opinion. I don't think that's a lie. And if it's coming from a Russian bot and it's being micro-targeted because someone has bought access through Facebook to send that message to particular people based on their demographics, I think that there could be a remedy for that. And as I'll argue in my book, that remedy might be a ban on micro-targeting of political ads. But that's not really about lies anymore. And even if you look at proposed congressional legislation, a lot of the proposals go beyond lies and they go to what are called misleading speech. And then we're in a real quagmire in terms of who's going to decide what's misleading and what does misleading mean. And there's not just a First Amendment problem. So one of the questions I'd like to ask is, even if we didn't have a First Amendment impediment, would we trust the government, say it's the Trump government if you don't like Trump, or it's the Biden government if you don't like Biden, would we trust a regulator in that administration to decide what's misleading and determine what can be included and not included? So I think, especially when we get beyond demonstrably empirically false information, things get very complicated very quickly.
But I mean, even if we stay there, I mean, just go back to Matt's interesting suggestion about having Congress act to make it a federal crime, such that Section 230 wouldn't apply, and the platforms now maybe face criminal liability if they post a lot of lies about the time, place, manner of elections. You know, I'm a free speech person, so my immediate response always to any of these like Section 230 carve-outs is chilling effects. So might we worry about people using the social media platforms to try and disseminate lots of valuable information about how to get to the vote, how to get to the ballot box, being chilled, or their posts being taken down by platforms that are worried about it? Just to go back to Rick's point, how do we distinguish between, you know, the negligent error and the intentional lie? Or to put a sort of a very a technical point on it, you know, what kind of standard of mens rea or intent do we want to have, even when we think about these sort of we're still in the easy case. We have some time, so we're going to get to the harder cases. But even the easy case, once you start pushing on it and you realize how contested the terrain of elections is in America, and how people really want to, there's opposing forces. You want to get people to the polls if you're on one side. You don't want to get people to the polls on the other. How do we think about the intent standard?
So we actually have a model for this. So in 2007, Barack Obama introduced this legislation, the Deceptive Practices in Voter Intimidation Act. That legislation is actually a part of HR 1. So it is, in theory, pending before the Senate. And if we pass widespread election reform, we would have a federal deceptive practices law on the books that would change platform liability as well, because it would be federal criminal law, which would be an exception to Section 230. That law says it makes it a federal criminal law to knowingly deceive any other person regarding the time, place, or manner conducting any federal election, or the qualifications for or restrictions on voter eligibility for any such election. So that is a relatively narrow law. It could be further narrowed through court challenge, I think, possibly. Genevieve, I think it's sufficiently narrow so that I would think the chilling effects would be relatively limited. Maybe that's me being naive about it, but it does seem, I would think that the issue here would be that this might be too narrow to address what we conceive of as the problem in elections, not that it would be so broad that it would impose significant chilling effects.
One could imagine a law that's not necessarily a criminal law that would punish people, but you could have a law that says that empirically verifiably false speech about when, where, and how people vote must be removed by the platforms. Just like we might have a law that says that they have to remove obscenity, or they have to remove speech that would imminently provoke violent action, right? So, that kind of law, we wouldn't care about the mens rea. So if a posting said you can vote by text, and that's false because we don't allow voting by text, then you'd have that removed, and we wouldn't have to worry about what the person's intent was at all.
And why don't we make that medium specific, though? Like for me, part of the challenge of the current moment is sloughing what I see as the government's duty to actually outline the scope of permissible speech, and to do that legislatively and then through judicial process. It seems like to send a signal, which I think is incorrect, that platforms are the sole place that we have manipulation and lies occurring that would be problematic, seems odd to me. And it would be strange to me that you'd be able to say something in a TV ad, for instance, but you wouldn't be able to say, or in a billboard, or in a placard in a lawn sign, but you wouldn't be permitted to say those things on a social network. And that for some reason that the First Amendment would distinguish between the two.
Yeah, no, I didn't mean to distinguish between the two. I just meant that the problem is most prevalent there. But certainly if such speech appeared on Newsmax or One America News Network, I think it should be subject to the same standard.
I do think it's interesting how in the conversation about lies, there is a lot of focus on platforms and much less focus on Fox News, which I read to be and Newsmax, major disseminator of the big lie. And so I suppose I want to open up Matt's question to the entire panel. I mean, do we think, are the platforms playing a special role here? Or do we think the problem of lies I mean, who's primarily responsible for regulating lies? Matt clearly thinks the federal government, but I mean, historically it's been the states that have done a lot of it. How do we think about the problem of Fox News, for example?
Well, I'll jump in if no one else wants to. I think that the problem is not just social media, but the reason that we focus on social media is that it provides the most unmediated way in which a demagogue can communicate with people. So Trump made over 400 false statements on Twitter between Election Day and the 3 weeks after Election Day, claiming that the election was stolen or that there was fraud. He made over 700 statements falsely claiming fraud, voter fraud, between 2012 and 2020. His statements are unmediated. If we go back to a world of 3 television networks, Trump could have been saying all of this stuff, but it would never have been repeated in the same way. It wouldn't have been picked up in the local newspapers, and it would lack the virality and the amplification. And so I think you can. One of the things that we see is a kind of symbiotic relationship between the claims made on social media and then the reporting on these cable news networks with the proliferation of media. And I think that what we can't ignore is that there's a profit motive here. Fox News, OAN, and Newsmax are giving the people what they want, and they're giving them ever more radical content because that's what's being demanded. And it's a kind of feedback loop between social media, and it's an entire cheap speech ecosystem. It's not just social media, but social media allowed Trump to jumpstart the false claims that never would have gotten traction in an earlier era. And that's why I think it's appropriate to focus on social media as a main problem, but certainly not the problem that comes with false election-related speech.
I guess moving on to from the easy question to a slightly less easy question. Atiba, I wanted to pick up on something you said in your blog post, because it suggested, it was interesting looking at the contrast between your post and Rick's post. Rick really wanted to narrow the scope of permissible regulation to election lies, not campaign lies. But you suggested that maybe we should think about regulation of speech that poses, I think, as you said, a clear and present danger of threatening the integrity of the electoral process. Can you say a little bit more about what you mean by that?
Yeah, so I think that, and in some ways, in my post, I think that, and I share the concern generally about the content of campaigning in and of itself, and a lot of it is opinion driven, and the kind of the half lies and puffery of standing up and saying, I'm Atiba Ellis and I'm running for whatever, is something that I'm not concerned about, in as much as that kind of chilling would make me worry. But when I think that there is speech, and I guess I take a vast lens to the kind of speech that sort of directly imperils the credibility of the process itself. I mean, in this election in particular, it was the big lie that was the problem, in as much as the big lie was this metastasized notion of voter fraud and rampant corruption that existed prior to the ballot in and of itself. I mean, of those thousands of lies that Rick mentioned, there were numerous lies about whether and how and to what extent mail-in voting could be a valid way of voting as opposed to other forms of voting, and direct accusations of political opponents that they were out to rig the system, right? And then the loss was, in essence, a self-fulfilling prophecy. And in a way, I can see how that in and of itself is puffery, but then when that gets actualized into lawsuits that get directed at elections that were otherwise clearly and objectively legitimate, to polling results in particular, and what I try to emphasize in my post is polling results that target the voting strength of people of color in particular, and sort of buy into another part of that lie, which is the worthiness of people of color to vote, which is the original sin of America in a way, in terms of American democracy, that this then becomes so dangerous that a stronger tact ought to be taken. And so, and mind you, this is an idea. You asked us to think out loud, and I was thinking out loud in this blog post. But part of my thought was that, in some ways, we have made those choices, particularly when it comes to race, in the choices that we've made regarding the Voting Rights Act. In fact, we can think of some of the specific provisions there, which, make illegal things like election intimidation, with the end of basically stymieing the votes of minorities. We see those as crimes. And we, in that context, in an act created prior to the era of the internet, would have a national consensus to say this is something that we ought not to allow. So in a way, my thought here is that when we see those types of red flags that move merely beyond puffery and typical campaigning to, in essence, creating an excuse to subvert an election, then heightened treatment seems to me to be deserved. I mean, that's my argument.
Yeah, this is so difficult in the sense that, I mean, we all recognize the value of free speech and not wanting to chill free speech, and the difficulty in regulating speech in this area because there's so much grayness in the types of in the content. So I think it's incredibly difficult to imagine. But we're kind of in a situation where we realize that as we're trying to balance that interest against whether we will actually continue to have a viable democracy, that there probably is some need to think about what lines are administrable that could be drawn to limit some of this incredibly dangerous speech. I mean, to some extent, you could say, and this is brainstorming here. I see I've frozen. Can you hear me? Can you continue? Can you still hear me? Okay, all right. I mean, to a certain extent, to the extent that we allow this rampant misinformation and disinformation to proceed in the way in which it currently is, we're kind of betting the farm in the sense that I think the core of our democracy is at risk here. And so we are, I mean, this is such an important conversation because we really do need to drill down and maybe take some kind of difficult decisions about whether freedoms that we have, kind of how do we kind of rethink that in this context where we are betting the farm. We're trying to protect those freedoms, but at the same time, we see that the freedoms may, just run right over us to where we lose them as well as the underlying democracy that's so critical. So we're in a really tough spot, and I think we're going to have to try to, maybe do some bite-sized ways to figure out what can you break off easily to try to see if we can put some protections around the easy space first, because it's a really important point that we haven't even protected the easy stuff, right? So that's incredibly important. So it's let's try to do that. Meanwhile, one of the things that I was thinking about in this balance and kind of tried to bring into the blog post was that the fundamental tenets of democracy and each person having a vote that will count equally in the process requires that we protect the mechanisms of voting. And that's not the topic of this panel. The topic is, kind of the freedom of speech. But I think these two come together. And in my mind, they come together in the sense that this is really tough. We need to see what is the best we can do in this space quickly. And we also need to protect the fundamental structure of our democracy in the voting process. Because that is kind of a bulwark against kind of being wiped away by the whole, or washed away, I should say, by the whole disinformation campaign and where things seem to be going in that space.
I guess I want to come back, Janelle, that's a great point. I want to come back to this question about structural regulation, thinking about maybe the solution is not targeting lies specifically, but in addition, other kinds of reforms.
In addition, I'm not taking it off the plate at all. It's very important.
But I guess I want to pick up on what I think I'm hearing a little bit of a disagreement between Atiba and Matt about the approach, maybe. Which is, Atiba, I mean, the approach you were suggesting, I think is much more in line with how we've done it traditionally at the federal level, which is we have this kind of unclear, capacious category that what we call conspiracy to interfere with rights or voter suppression, voter interference, that some federal prosecutors interpreted sometimes to include false speech when it's being used for those purposes. Now, the advantage of that kind of approach is that all lies are not the same. If you're lying as part of a concerted campaign to subvert the outcome of the 2020 election, that looks very different than if you're lying because you're trying to puff yourself up to your friends. And maybe it allows there to be some distinctions being made there. But of course, it has the downside that it's not so clear exactly which lies are being prohibited and which lies are not. So I suppose I want to hear maybe from Matt, from Atiba. I mean, do we actually want to have a less clear regulation of lies that can take into account the sort of very bizarre specificity or unusual, I guess, hopefully anomalous nature of things like the big lie and disaggregate that from other kinds of lies? I mean, how do we deal with the big lie? I guess we're putting the hard question on the table.
We sort of dealt with the big lie. We voted the president out of office. Hopefully we'll prosecute people who were responsible for January 6th. I think those are two positive developments. I think one concern that I have in discussions of the First Amendment is that we often sort of describe it as a barrier that we just need to overcome to get to policy objectives that we know are preferable. And I understand the desire to do that, but I think the First Amendment and the jurisprudence that has developed around it makes sense for many reasons. And I think my understanding of one of the kind of core ideas is not that it is a value judgment on how good all speech is. The purpose of the First Amendment isn't to say that all speech is good. The animating principle is that restraints on speech tend to be counterproductive. And I think that we've actually seen that even in limited evidence that we have about how platforms have intervened to try to address things like the big lie. So at NYU, in their NYU has a Center for Social Media and Politics, they did a study of Twitter's attempt to regulate President Trump's speech through misinformation labels. And what they found was that messages with warning labels actually spread further and longer on Twitter than did those without labels. And I think that is sort of in line with kind of First Amendment, the ideas underlying the First Amendment, which is we may find any number of different forms of speech or content of speech to be problematic, but when government, or in some cases platforms, attempt to regulate it, the results that we can get can be counterproductive.
Although this raises an interesting question. I mean, one of the things that I have argued, before the big lie is the idea that the disinformation of voter fraud has a longer legacy than Trump's arguments, right? And that particular lie, if you will, keeps getting repeated and keeps getting modulated. Maybe it sometimes looks like opinion, but it seems counterproductive to the goal of having all people who wish to vote, and to be able to perceive the system as welcoming their participation. So in some ways, I wonder whether, the continued spread of the big lie may well be a problem if that spread is uncontextualized, right? And or in other words, the data may say that conversations about the lie persist, but then I guess, and I haven't read this study, so I would just want to ask the next question. Is that mentioning of the lie in terms of repeating it for the truth of, the truth of the lie, but repeating it in a way that the lie is believed, or in a way that the lie is being countered, right? There's lots of folks who talk about rhetoric, who talk about how, well, the challenge of fighting a lie is you have to name the lie in order to defeat it. And to me, this is one of the most sticking points. But I would err in the side of, and it consistent with First Amendment values, naming the speech, but at the same time having conversations that help confine and defeat the purpose of the speech. And my understanding of all this is that this is oftentimes relational. It's a problem of talking about what we're talking about rather than sort of erasing. And this is what I mean in my blog post about epistemic crisis, in terms of erasing the line between what's apparently true and what's apparently false, so that in the blurry area, we just go with what feels right, which then means along our partisan divides, half of us want to combat the speech of the big lie and assert that Biden is the winner, and half of us don't believe that Biden is the winner, and keep saying and keep on doing things like investigating an election 18 months after it's over. And so in that way, I would tend towards, if the lie's out there, then we have to sort of name it for what it is and use the ability of platforms, which is sort of what Twitter tried to do, and to a lesser extent, Facebook, sure. But I guess I am leaning more towards aggression because I guess I get fixed on the fact that January 6th happened as sort of the end point of this rampant campaign of disinformation. The clear and present danger became clear when it went beyond protest to violence. And so it just leaves for me the question of, is there a point before the Capitol gets breached where we should step in?
So I think one way of thinking about this. Oh, sorry. Go ahead.
No, go.
I was going to. One way of thinking about this is to not limit ourselves to direct speech regulation, saying, for example, that Trump can't speak about the integrity of mail-in balloting, because even if you say you can't make false statements about when, where, and how people vote, lots of Trump statements were in the form of, there's no way they can have a fair election in California. It's going to be rigged, which I take it is not a statement that could be empirically proven false and to be removed. So rather than think about the kind of regulation of speech coming from the government, we can think about other means by which we're trying to counter the big lie today. So one was the decision to deplatform Trump from Twitter and Facebook, which were decisions made by private companies. I think that the labeling of Trump's tweets and Facebook posts was counterproductive. And I'll be arguing in the book that it actually helped facilitate the spreading of his information on Facebook, where the labels seemed to indicate that Trump was telling the truth, not lying. So things can be done badly, but there's pressure coming not just from the public and not just from congressional hearings, but also from Facebook employees themselves who did not want to be complicit in spreading these things. The OAN, probably the worst offender among the cable news networks in sharing Trump's lie. Well, there was Reuters reporting last week that 90% of OAN's revenues come from AT&T carrying this network full of lies on their DirecTV platform. So now there's going to be political pressure on AT&T. People have a right to free speech. They don't have a right to have large corporations pay to perpetuate lies that undermine elections. And even in the legal realm, we're now seeing bar complaints being filed, sanction motions being made by lawyers who lie about elections in the context of their role as lawyers in courts. So I think there are a lot of levers to think about this beyond trying to regulate the speech itself of the bad actor. And it doesn't have to be a one or another thing. I think we need to think about this as a suite of ways of trying to respond. It's a multifaceted problem that requires multifaceted solutions.
Yeah, although Rick, I mean, that's very helpful, but also raises all kinds of questions for me about who do we want to be making these decisions about how to regulate lies, both directly and indirectly through disclosure and other mechanisms. Because of course, there's the advantage of private companies. They're not the government. They're not the entity that is perhaps going to be voted out of power in the next election who's making the rules. So there's a separation, which maybe makes us feel better. It's easier to leave Facebook than it maybe to leave the United States. I think so. Yeah, let's just say it is. On the other hand, though, if we're talking about the regulation of speech that is core to our democracy, there is something disturbing about having important decisions being made by non-transparent, profit-oriented corporations in which there's very little political buy-in. And so there is a tendency, I think Trump's deplatforming after the big lie, in large part because of the lie, although I think none of the platforms said it was the lie. It was really the glorification of violence or the incitement of violence. But let's say it had to do with the lie and the results of the lie. The deplatforming felt like such a relief. Someone's taking action. At least the platforms are doing something. On the other hand, it does, obviously illuminate the power of these private companies. So how comfortable should we be about the private companies playing the central role, rather than the government?
Well,
I think we need to take. I'll jump in. Well, I'll keep going. I was going to say, I think we need to take a very close look at what is the appropriate regulation of these private companies that control really the public square and the ability of people to share information and to get information, kind of just at the, touch of a finger. And so I think that the government is going to have to set up regulatory agencies to look at these institutions and decide what is the smart way to make them work within our democratic system, to fit them in so they're just not runaway institutions controlled by different private actors who today may think one way and tomorrow may think another. So I do think that's a critical piece of this. I don't know what kind of the fix is, but we clearly as a nation need to get our arms around, or as a really globally get our arms around what's happening with these behemoth, big tech actors and the use of their platforms and the control of information on those platforms, because we see how it can be very dangerous. The use of algorithms that just, kind of spew out, more and more extremist content and drive people in to extreme positions is incredibly dangerous, and that does need to be regulated and controlled. At the same time, as we look at this, I have to put one more question, which is going to sound like like the little kid asking the question in the room. But we talk about the big lie, but in many ways, I ask: are many of those people who say that the election was stolen, do they really believe it? I kind of feel like it's just a political mechanism by which people say which side of the line they're on. And so, we could focus all of our attention on the fact that these are untrue statements, but I do have to question the extent to which people truly believe them, that they've been convinced that this is the reality. I know there are some, and some number of them, and the extent to which this is just a political device by which to say, which side of the line are you on? And you claim it if you're on that side of the line, you claim it was stolen, and if you're on the other, you don't. But it's a mechanism. It's just a tool to me. And so while I think we should look at, how do we stop that? I don't know that stopping it is really going to produce the outcome, because I'm not sure people really were, what numbers of people really are convinced that the election is stolen. I know people give that response in surveys, but that's why I said this is maybe the little kid in the room asking, is it real? Is it real? Or is it just a political device by which we, as a nation, have divided ourselves?
I can tell you from my inbox that there are many, many, many people who believe this. And some of the most interesting polling was at CNN that found that 59% of Republicans said that it's important for what it means to be a Republican to embrace Trump's statements that the election was stolen. And so I think,
That's
it's
my
not
point.
even anymore. Right?
That's exactly my point, Rick.
But they actually believe it, so I don't think most of the elected officials who are saying it, who understand how elections work, believe it. But I think a lot of the rank and file do believe it. But to get back to the kind of the question about, do we trust the platforms to have this power? I think there are a few answers aside from saying that we're going to pass a law that says that here's when you have to deplatform a candidate. I don't know what that kind of law would look like. The first is, if we're worried about platform power, then we should address platform power through antitrust law and privacy law rather than through speech law. So if Facebook is too big, if it has too much power in the marketplace, break it up. It shouldn't own Instagram. It shouldn't own WhatsApp, right? And if the problem is not lies that are being disseminated, but extreme views and polarizing content that is driving us to a bad place as a society, that's different than lies. I think the answer to that then is to ban the micro-targeting of political ads, or to ban micro-targeting entirely, as some privacy scholars have advocated. That would undermine the business model of these companies. It raises different First Amendment questions about whether data collection can be treated like speech. But I think those are the kinds of questions to ask about the platforms, rather than questions about regulating their election-related speech directly, aside from narrow carve-outs like for the easy case that we're calling it, which I think is not that easy, about false speech about when, where, and how people vote.
I know we're not focused on micro-targeting, but I do think banning micro-targeting would introduce its own set of First Amendment concerns. I also think it would actually likely be counterproductive, in that micro-targeting is mainly just an efficiency device. So it makes it easier, I think, typically for less well-resourced advertisers, including less well-resourced campaigns, to run more effective advertising campaigns. They pay less money to reach the people who they would like to reach. And so for campaigns that find it harder to run ads on television, for instance, ads on social media end up being an attractive proposition. So I would be concerned about restraints on micro-targeting, not just from a First Amendment perspective, which I think probably all of the other panelists are better equipped to weigh in on those issues, but also in terms of its potential impact on a range of different types of campaigns. Banning micro-targeting would have very limited impact on someone like Donald Trump, who can use organic content and a lot of free media attention to reach a huge number of people. I am going back to the question that you raised about platforms acting on their own. I'm really deeply concerned about that dynamic, where we attempt to govern by bully pulpit, and we don't actually push Congress to pass legislation, outline what's permissible and not. Instead, there are hearings, there are speeches, there are op-eds that put a lot of pressure on platforms, and platforms, I think, not to their credit, respond to that pressure by enacting speech restraints that the government would be prohibited from enacting on its own. Often, I think, that may have problematic consequences for speech. A good example, I think, are the ad bans from the 2020 election, which a study that I did when I was at Duke University found that those bans probably had no effect on misinformation, harmed less well-resourced campaigns, and because of how Democrats use social media relative to Republicans, probably hurt Democrat campaigns more than Republican campaigns. I think we're at this odd moment right now where there are a lot of people who, in two separate sentences, but sort of back to back, will say, we need platforms to play a more aggressive role in moderating content on their platform when there's controversial speech. And then in the next sentence say, we are deeply concerned about the power that tech platforms have. Stronger intermediaries that are more aggressively censoring and moderating speech, I think that's a way of aggregating power in tech platforms. The more it costs, the more difficult and complicated content moderation becomes, the more sophisticated the systems are that you need to deploy to moderate content, the more difficult it is for smaller platforms to challenge larger platforms and to outcompete them on issues like content moderation. So I'm concerned about that development, which is one of the reasons why I think it's so important that regardless of what we think about the hard issue, as a starting point, we really need to push Congress to, if we as a society want to take voter suppression seriously, then we should push Congress to take voter suppression seriously by passing a law.
Which is a whole other conversation in and of itself. Although I do agree with the train of thought here and I'll just simply add one other thought, which is the profit motive that Rick mentioned earlier as the incentive to allow the big lie to promulgate would still not be removed if we ask these questions. And I think, the recognition that the platforms and the companies are well experienced in finding ways of taking the rules to game them to their advantage and not necessarily to the advantage of the political community, when coupled with the profit motive that they have, seems to me to just say, well, there are new and inventive ways that can be used to aggravate the problem that we're complaining about rather than solve it. So It is a dangerous place to be, not realizing that I'm probably one of those people that Matt observed who is also wanting, crackdowns because I directly argued for labels and whatnot. And now I need to revisit that view. But anyway, you get my point.
Okay, but to take the counter position, so I'm no fan of big corporate power, including big corporate power over speech. But I think the rub and the reason why this is actually a genuinely difficult question is that saying, well, we want this to be the government acting. We want it through the democratic political process, not through the platforms. Well, I suppose there's two problems, one of which I referred to before, which is this real problem of incumbency, self-interest, that the government is a directly involved player here. And so it becomes problematic whenever we regulate elections. Although, of course, that's not a good argument for deregulation. So leaving that aside, the second problem is the First Amendment. So saying we don't really want the platforms playing a primary role. We want Congress, or maybe the states, but let's say Congress. Means that ultimately, I think, Matt, as you suggested in your post as well, it's going to be the Supreme Court or the federal courts that are going to be deciding whether or not this is permissible. And we have a very laissez-faire First Amendment that allows a lot of bad speech out there. And we may think it's good. We may think it's bad. Now, I guess I would say just that I think the First Amendment law of lies is less clear than a lot of people think. So Alvarez, to go back to the opinion that Rick was talking about at the top, it's a plurality opinion, and it says something like, Rick, push back if you disagree with me, but this is how I read it. It says something like, well, lies that cause real harm can be regulated, but lies that don't cause real harm cannot. And then we, the court, we're going to decide what real harm is. It's going to be fraud. It's going to be if you impersonate a government officer, sure, that's real harm. But just talking about whether or not you've gotten a medal for your military service, that doesn't count as real harm. So Alvarez, to me, seems to presume that there's this kind of natural or objective distinction between the kind of lies that matter and the kind of lies that do not. And I think in this context, this is maybe why the big lie is so difficult to think through, because obviously lies that disenfranchise voters by giving them the wrong polling place, that's an obvious harm. But the big lie, I mean, I think as we've talked about, Janelle talked about, Atticus talked, Atiba talked about, it has real harm too, right? Like, it's just not, Rick, you said disenfranchising, but doesn't the big lie disenfranchise as well, just in a less direct way? So anyway, I think that there's a lot of questions about how the First Amendment would be interpreted or could be interpreted to allow the regulation of lies. But we can, as a predictive matter, assume, I think, that the Supreme Court is not going to be very receptive to lots of regulation of lies. So are we okay saying, well, we don't want platforms playing such a role for all these good reasons, and therefore we're just going to allow a lot of false speech to circulate?
I think it's kind of strange what's happening at the Supreme Court right now. I too used to view it as a laissez-faire or libertarian court on these issues. But then you look at Justice Thomas's concurring opinion in the Knight First Amendment Institute case, in which he suggests that states could pass laws that require platforms to carry all politicians, a way of restoring Trump to Twitter and Facebook, analogizing to the common carrier position. And I know this is something, Genevieve, you've written a lot about. Or you look at Justice Gorsuch's statement with respect to the denial of cert in the Berisha case last term, where he pointed to the problem of disinformation and the collapse of the economic model for local journalism. And that was a reason to make it easier to sue for libel. So it's not clear to me that this is a libertarian court anymore. This is a court that is selectively libertarian, that is conservative in its orientation, and that is choosing to line up with Trump on two issues that he cares about: opening up the libel laws, and as Trump has put it, and restoring him to his platform. And you see Florida following through with a law that would purport to require all social media companies, except those owned by theme parks, which is a nice Florida twist, all social media companies to carry all politicians. So I think the court, not only is the court's libertarianism potentially damaging to our democracy when it comes to dealing with false speech in elections, it could actually be affirmatively harmful in the places where it's not libertarian.
So I think one question about your question is, to put it in tech parlance, is the First Amendment a feature or a bug? And you've actually, I think you, even in various different times in our conversation, you framed it in both directions. So I think initially you were worrying, I think very appropriately so, about, for something like a federal deceptive practices law, would that chill important speech? I think that is a really important concern. The question you've just now asked is, but is that law too limited and too narrow to address our concerns about harmful speech in our democracy? And I think that's an appropriate question as well. I think the sort of macro question that governs all of it is, who is the right one to try to resolve? What is the right entity to try to resolve those questions? And I don't think it's first and foremost platforms. If Congress were unable to get law through the political process, if there were real political barriers to passing law that governs how we think about speech in our democracy, that seems important. I think we have a system rooted in the importance of being able to have political momentum to get something through the legislative process. That's an important component of what we decide is permissible and not permissible in our country. If it were to make its way through Congress and the Supreme Court were to narrow the law in some way or to strike it down, that also is an important check in our system, to have the Supreme Court review the constitutionality of the law. I don't think, in the absence of political momentum or the absence of the judicial space to make this happen, that it should fall to companies like Facebook and Google or Snap and TikTok to make those determinations entirely on their own.
So I think I'm going to turn now to some of the questions we've been getting in the chat, and one of them is very relevant on this. So John wants to know, do the panelists advocate for a new exception to the First Amendment? If we think that the law is unclear, should we expand, not taking the current doctrinal categories for granted? I think, as Rick suggested, First Amendment law is in a lot of flux. And so is there a good argument then? Matt, is that what you're suggesting, that we should expand the category of lies that the First Amendment would allow somewhat? Or are...
Well, I'm not sure. I think there are other. I think everyone else could probably weigh in on, like, doctrinally what might be required to happen. But my sense is that within existing First Amendment jurisprudence, that the proposed deceptive practices law might be permitted. But I do think it would be helpful to have an opinion on that, to get at some of the issues that I think we're all speculating about, but don't really have definitive answers from the court on.
I think it's a loaded question. It assumes that you'd need a new exception to the First Amendment as opposed to the proper interpretation of the First Amendment. And an interpretation of the First Amendment that doesn't read it as a suicide pact that requires us to destroy our democracy, that allows for our elections to be subverted, is not a reading of the First Amendment that I think is the best reading for our current times. Years ago, when we went through the whole clear and present danger test and we were dealing with insurrection, the real danger then was about censorship, government censorship. And I think today the dangers are different. Today the dangers are not just disinformation, but also extremist rhetoric that undermines the ability of Americans who have very divergent ideologies and beliefs to get along and function as a country. And so the First Amendment should be interpreted so that we can have robust elections and we can have fair competition, but still have meaningful limits on how platforms and cable companies and others operate in a way to assure that we have a vibrant debate that's not full of disinformation and that gives voters and non-voters who are living here more autonomy about how messages are directed at them, especially when they give up so much of their privacy inadvertently when they sign terms of service with these private companies.
I think that part of the way to get there is this laissez-faire First Amendment premise and sort of interrogating it properly. I think that I feel, from my understanding of First Amendment doctrine, realizing that things are in flux, but at the same time, the sort of attitude of laissez-faire, I think, and my sense is that inhibits our ability to ask the questions that Rick is asking. Not that at the end of the day, the doctrine might need to change. I think it's right to say, well, we can interpret it more aptly for our times, but there are those who take the leave alone philosophy, setting the court aside for one moment, just talking to scholars and people who think through the public, and I'll just observe as well that there are lots of people in society who sort of rail about how their conception of free speech means that they get to say anything they want without any consequences. All of this in and of itself is just lots of misunderstandings of the First Amendment that I think stem from a laissez-faire attitude about it. And so in a lot of ways, there is this turning, we live in a world where things are turned on its head in terms of what the goal is. And addressing that, I think, is an essential step to this end I think we all want to get to.
Yeah, I mean, both of your answers are really interesting because they push immediately beyond the question of lies to a broader category that we might think of as radicalizing speech or maybe polarizing speech, or this idea of sort of free speech, right, where you can speak without consequence. And so it re-ups, I think, Janelle's question about how significant is the lying, the fact that it's a lie. Doctrinally, it's easy to focus on the fact that it's a lie because the courts have recognized that lies are especially bad kinds of speech acts in certain contexts. But maybe it's a misunderstanding to be focusing this panel, this series, this conversation on the lie per se, rather than a broader category of speech that we might think of as, I don't know, polarizing speech or undermining democracy, undermining speech. I don't know how to think about it. And just to put a finer point on it, I want to ask Natalie's question. She says, there's an obviously dangerous cycle where disinformation degrades trust in institutions such that any response from institutions may worsen rather than improve trust. Is a good starting point to respond to the question, to think about the answer to this question before we think about anything else, which is, why was the propaganda of the big lie effective? Not assume that the lie is inevitably going to be powerful and we have to stamp it out, but what are the conditions under which the big lie can be effective? Thoughts from the panelists?
Yeah, I think that that's kind of what I was trying to get at, which is while I think we've got to continue to struggle with these difficult issues here that we're addressing on the panel. I don't think we, kind of in any way give ourselves a pass on that. But I do think that the intersection of what's happened with the lies and how the lies are used, the lies, in my view, are a tool to, I mean, for example, on election, the big lie about election voter fraud, that's a tool for voter suppression. Just like in the critical race theory, the attack on teaching the true history of the United States, the racial history of the United States, the lie is that there were things that were discriminatory, that this is a discriminatory process by teaching people, or that it's harmful to teach people what actually happened, the ugly racial history of this country. So it's being used, these statements are being used really to divide people into camps, as I see it, and very much with a racial through a racial lens, and that division motivates. It motivates and is useful for politicians who want to do or exploit that division. It was useful for the Russians, but it was also apparently useful for Mr. Trump to exploit that division. And so these statements, in my view, they are untrue. The whole attack on teaching on history curricula, is a way to incite racial division to me. And so this is just such a complex issue. I had difficulty trying to view it without crossing over. I feel like I feel like I'm crossing over and pulling in other issues. But these are mechanisms that are used to accomplish a political end. And in the U.S., with race being the Achilles heel of the nation from the founding, it's something that's easily exploited. And so I think these lies, while we have to confront them. So we have to use the tools that we have in our toolbox. So if we've got a way to control or restrict deceptive practices, we need to use those. We need to challenge, like the Legal Defense Fund did, Trump's Election Integrity Commission. These things, we have to be on our game. But I do think there are many ways in which we have to challenge these lies. The First Amendment and kind of how we interpret that is a piece of it. I don't know that we're going to get to where we want to be through this tool alone, however. I think it's multifaceted, and we've got to look at it from all these different angles. What do we do? I mean, we, in our own election protection operation, we trained lots of volunteers to look at what was out there, and when they found disinformation and misinformation, we trained people on how to correct it, how to go out and take it on. And so there are many, many ways in which we have to look at what this is doing to our nation. And this is an important piece of it. So, I mean, I would love to see a great, some key takeaways as to what we should do and how we should regulate in this area, and how the First Amendment should really be interpreted that we can all get behind. I think it's a critical part of the answer, but not the answer in and of itself or by itself.
Can I ask a sort of deliberately provocative question? I'm actually like genuinely curious about this. What separates the lies on the left from the lies on the right? So we're talking now about lies propagated by President Trump and allies of President Trump, but there are any number of misleading statements or misinformation that come from the left as well. My personal political preferences are that I prefer the misleading information from the left relative to the right. And I think I tend to think the misleading information on the left is probably on balance good for the future of our democracy, and the misleading information on the right is bad for the future of our democracy. But the concerns that I have about more aggressive regulation of misleading information, particularly when it comes through undemocratic processes like platforms just deciding because of editorials in the New York Times or the Wall Street Journal that they're going to make certain decisions on how to moderate content, is that my lies might be prohibited as much as someone else's. I'm kind of curious because I feel like as we talk about the big lie and sort of framings of political lies, that it seems like an underlying assumption of our group, at least, is that lies from one political persuasion are somewhat different than lies from a different political persuasion.
So I would say that the highest danger election-related lie are lies about the integrity of the election. And I think Janelle is exactly right that if you look at the history in 2016 and in 2020, the purpose of those lies was to depress African American turnout and to serve as the predicate for passing laws that make it harder for people to register and to vote. But I think by the end of 2020, things have gotten much worse. And that no longer is it about suppressing the vote, which is terrible enough in and of itself, but it's about subverting election outcomes in the future. I have a paper that'll be out in the spring in the Harvard Law Review Forum on election subversion in the United States. I think it's a real danger. As someone who studies elections, I'm more of an elections person than a First Amendment person. I've never been more worried about the integrity of our democracy than I am right now. I am worried that this big lie will serve as the predicate for an actual stolen election in 2024. And I go through the mechanisms by which that would happen, but in part it's that those who stood up to the attempts to try to subvert election outcomes in 2020 will be replaced by 2024 with Trump loyalists who will be in a position to actually rely on false claims of election fraud to overturn the results of the election. Again, there's some technical, complicated arguments as to how that happens in the Electoral College, but I think these kinds of lies raise unique dangers. And I don't care if those lies are coming from the left or the right, but lies that election results cannot be trusted when there is no sound basis to mistrust the election results. I think those are of paramount danger. And it goes back to something Genevieve was talking earlier about the Alvarez case. And when the Supreme Court said it's okay to say forbid perjury or forbid fraud, the problem with political speech is that it is both high valued to have political speech, to have a robust competitive election, and high danger when people infect lies, right? There is no high value to committing perjury or speaking fraud. But because the very process by which we would determine when political speech is a lie is itself political, it raises the very dangers that Matt is talking about. Who is going to be the regulator who's going to tell us that the speech is false? And that's why I think leaning on the platforms is maybe a second best solution, because I don't think that even if we could write, not worrying about the Supreme Court regulation that would deal with lots of this kind of speech, they would actually be able to come up with something that wouldn't be capable of manipulation by bad political actors on the other side, whatever side that is.
Yeah, it's hard to imagine that we can come up with that.
Well, Laurie in the questions asks, well, what about the specific case of elected and government officials lying? Is that a different case? So we've been talking very generally about lies and political lies about elections, but should we disaggregate it? I mean, there's a number of ways we can disaggregate it. We can think domestic lies versus foreign lies. But Laurie's question is, what about when government officials lie? Is it possible to imagine regulating that speech differently? I guess on the view that you're an elected official, you have a higher standard to tell the truth. And so there is something potentially particularly damaging, particularly dangerous about the president lying. Thoughts about that? I mean, does that make it easier, or does that not really solve the problem?
I mean, they're politicians. I mean, the elected officials are politicians. That's how they got elected. So they're in the political process. And the fact that they are elected to office, I don't think really is a line that is very helpful in trying to figure out what can be administered honestly in this space. Because if you have a rule of law, it should apply equally. And I just don't see how that line will help us to administer that some restrictions more effectively. I don't know that will help.
Facebook and Twitter, of course, did the opposite. They gave a special pass to elected officials. Say, other people can't say stuff like this, but because it's Trump, we're going to let him say it. And I think we should flip that on its head and say, not just politicians, but those with a large platform, those with a large following, should be especially responsible in not spreading lies about elections. And so I wouldn't draw the line between politicians and non-politicians, but I would say that those who are the most prominent who have the biggest megaphone are the ones that deserve, if not law, publicly being called out when they make false election statements.
Well, of course, the argument that they made was, I think, exactly the argument, Rick, that you just made about the complexity of political lies, that there's a lot of value as well as harm, right? So the argument is that the reason we're going to treat politicians like Trump differently than other speakers is that their speech is more newsworthy. It's important for it to be disseminated. And so we're not going to constrain its dissemination in the way we do ordinary small potatoes posters.
Yeah, that's a charitable way of putting it. I would say the less charitable way of putting it is that they didn't want to face Trump's wrath and the potential for regulation. And so they, and we know that Mark Zuckerberg did this with others. We know that they had a strike system to remove or demote content where there was numerous false claims being made, and that Zuckerberg and others overruled it when it was applied to Breitbart and others because they were afraid of the political blowback. So it's not clear that they were even administering their own rules fairly, and it's not clear that they want to look closely into their own role in the process of helping to create the conditions for the January 6th insurrection.
And actually, let me just pick up right there, because I think Rick said something very important about this. And it actually, for me, it ties back to the prior bit of the conversation. I agree with the questioner that maybe there ought to be a role, particularly for governmental officers. I think Caroline Corbin wrote a paper about a duty about speech when one is the government. That helped me think about this a bit. But yeah, I think that there is a duty incumbent upon elected officials to preserve, protect, and defend the Constitution. And part of that is about not misrepresenting the results of an election when they are there. Of course, for me, I think of the thorny part of this problem as is Trump or Biden or whomever speaking as a sworn officer of the United States or speaking as a politician. And then that gets to the sort of grayness of all this. But my instinct is to err on the side of, when it comes to the clearest and most present danger of subverting elections itself, to be most critical of that speech and penalize it, in as much as, we saw the results of 2021, but I also think back to 1896 and 1920 in terms of watching this sort of ideology of racial voter oppression metastasize into race riots directly designed to subvert the Black vote. And where legal regulation didn't work historically and intimidation didn't work, then outright violence was the end result. And in some ways, I think of 2021 not only as a sort of voter fraud driven insurrection, but echoing, our worst times in American history after the Civil War. So I guess I've just put out there that I read all this through that lens. And to me, that heightens the danger even further that we're talking about.
Well, I think it suggests a separate danger. We've been talking a lot about the problem of disenfranchisement and then the threat to the next election. But I think, Atiba, in your post as well, you suggested another danger is to tell a false narrative about the present and the past. And so the worry, I suppose, is that going forward, what the big lie is going to do is for some Americans, it's going to produce a different understanding, a different story of what has happened and what is going to happen.
Mm-hmm.
There is a way in which I think there's large segments of the population that think Biden's presidency is illegitimate. But that, to me, that's the kind of stuff of politics, right? That's deep political narrative happening. It's just happening through the lies. And so I suppose I'm not sure actually what the government, except through thinking about education or its own forms of speech, can really do about that, these kinds of the problems of narrative and lies.
Right. And that's what I tried to emphasize at the end of my post, that maybe the most fundamental thing we can do is articulate the counter narrative. And given my allusion to the Civil War, the rhetoric of the lost cause sort of illustrates this. The Civil War was changed from a war about slavery and into a war about states' rights, and suddenly the narrative obscured the actual reality of the situation. I hear you when you say, well, that kind of dynamic can happen here. So in a sense, we get back to the core of the First Amendment. What kind of valuable affirmative speech can be said by government itself, and which means the political choices that get made to see who is the speaker in government to preserve the democracy by educating people about its dynamics and its complications, and encouraging all of us to have conversations like these where we make these issues clear.
Yeah, I think it's right that delegitimizing a president is not new with lies. There's a kind of a through line from lies about Barack Obama's birth certificate to lies about Joe Biden and the stolen election. But the difference is that these particular lies at this moment in American history might serve to actually create the conditions, because of the Byzantine way in which we choose the American president through this convoluted electoral college process, to actually overturn the results of the next election. So I think, you could think of it as a continuation, or you could think of it as an escalation in a particularly dangerous way. And that's not to say that the solution is necessarily government regulation, but that it's an all hands on deck moment in terms of our democracy, because lies about that the last election was not fair and that the last election was stolen, that undermines the very premise of democracy, that the losers are going to accept the results legitimate and agree to fight another day. If we don't have that, we don't have our democracy.
So Rick, I hear the point you're making. It's a depressing, but it's a really powerful point, which is that the big lie is still unfolding. We're not talking about the past, we're talking about the present, right? And how we deal with a lie that is continuing to have effects, not a lie that has ceased being effective.
Right. I'm much more worried about 2024 in connection to the claims that the 2020 election was stolen than about 2020. 2020 is over. We're not going to decertify Biden's win, despite what the My Pillow guy might tell you. There's not going to be a secret Trump inauguration in 2022. But I am worried about 2024 in a very profound way.
Well, unfortunately, we are out of time. This has been a really wonderful conversation that I'm going to be thinking about for a while. I just want to thank the panelists for participating and everyone for coming. I want to say that we're going to have another roundtable on lies in the press, looking at the future of New York Times v. Sullivan on November 19th. That is going to be an in-person event in New York City, but we are going to be Zooming it or live streaming it, so you can register for that too. And as Katie said at the top, all of the really rich blog posts that the panelists wrote for today's event are at the Lies in the Law homepage at the Knight Institute at Columbia website. And so thanks everyone for participating. This is, I'm sure, not the end of the conversation, but it's been a really good one. Bye-bye.